Hello everyone, good afternoon and very good evening to all of you. I am Manya Khanna and I am Operations and Corporate Relation Associate. Welcome you all on behalf of Karuna Mediation and Arbitration Institute and our founder, Mr. Sahil Kapoor. As Mr. Sahil Kapoor is being a family dispute resolution practitioner and a mediation enthusiast, he founded Karuna Mediation and Arbitration Institute with a vision to spread awareness of mediation for resolving disputes with compassion and empathy. In progress and awareness towards mediation, we organize related webinars to spread awareness about mediation for students and professionals who all will be the future building blocks for this particular sector. Today's panel discussion will be on mediation advocacy, and to impart and share knowledge about today's topic, we have not one but our three amazing expert panelists who will throw lights to all the facts related to mediation advocacy and how one can be a successful professional mediation advocate. I would like to introduce to you all with our expert panelist, Ms. Uma Ramanathan. She is an advocate, mediator, and a mediator trainer. She got herself trained in mediation by Ms. Geeta Ravindra. She is also the organizing secretary of the Tamil Nadu Mediation and Conciliation Center, High Court of Madras. She practiced as an advocate in the High Court of Madras, Tamil Nadu, India for the 29 years. She has been practicing as a mediator since 2005 and training mediators all over India since 2008. She is also a member for the panel constituted to draft the mediation manual brought out by the Mediation and Conciliation Project Committee, Supreme Court of India. She is also a managing trustee for the Foundation of Comprehensive Dispute Resolution and also a panelist among various programs, workshops, seminars related to mediation. She also contributed many articles related to mediation and author of the book Resolve to Resolve. Thank you, ma'am. So now I would like to introduce our second panelist, Ms. Virash. She is an advocate, practicing mediator, and the director of Fair Practice, a dispute resolution service organization based in Johannesburg, South Africa. She is a graduate of Arbitration Foundation of South Africa, University of Pretoria, in dispute resolution, and is the lead trainer of the Fair Practice and Arbitration Foundation of South Africa in mediation and negotiation training skills. Over the past 7 years, she has trained professionals from different sectors. She is a Harvard trainer mediator and a negotiator too, and also an internationally accredited civil commercial mediator and negotiator through the Center for Dispute Resolution UK and ADR ODR International UK. She is the South African representative for the ADR ODR International and also a trustee of the organization Mala Ibana, a voice against child abuse, which is established in South Africa. Welcome, ma'am. Now I would like to introduce Mr. AJ Jawad. He is an advocate and semi-accredited mediator based in Chennai. He is one of our advisory board members, is also an accredited digital dispute resolution specialist with ADR ODR International UK and a partner head of the ADR services at Cadillac Chambers LLP, Gurugram, Delhi. He has been a senior mediator trainer, which is working globally, work as a mediator and trainer with the Mediation and Conciliation Project Committee of the Supreme Court of India, and also a co-founder and a former trustee of Foundation for Comprehensive Dispute Resolution based in Chennai. He has more than 17 years of experience in conducting civil, commercial, and matrimonial disputes mediation. He has impaneled as an India specialist mediator in the Singapore International Mediation Center and the Bombay Chamber of Commerce, and a guest faculty for the master degree course in mediation at the Maharashtra National Law University, and also impaneled as an arbitrator with the Madras High Court Arbitration Center and the Indo-German Chamber of Commerce. It's a pleasure for us and our audience to have you, all of us. And before proceeding further, I request to all the participants to please switch on your cameras if possible. Then only it will be having an interactive session. And please mute all your mics. And regarding the questions, then we will be having all the questions later in the session. I request all of you to please put down your question with yourself or write it down in the chat box. So yeah, can we start, please? Yes, sure. As in our previous webinar series, Mediation Advocacy, we had the viewpoints of Dr. Raman Hingorani, sir, Ms. Emma McKendry, and Ms. Pushpa Gupta. So, but today we will be discussing the viewpoints on mediation advocacy and how advocacy helps in leading towards a successful mediation. Now, with all of your due permission, I would like to raise my first question. Can I please, sir and ma'am?
Sure.
Okay. So my first question is, what are the ethics of mediation advocacy, and can a mediator advocate with the help of the parties finalize a mediator if required for the mediation? And does it affect the ethics of the mediation advocacy? I request Uma ma'am to please answer the first.
Thank you, Manya. See, when this question is very interesting because there is always a doubt whether reaching out to a mediator creates some kind of, background information or need which is already expressed to the mediator. Now, let's first understand what advocacy is, especially in terms of mediation. Now, I see advocacy here as a wider social change, which, what shall I say, helps to understand attitudes and what are the kind of dynamics that are there in social relationships and power relations. So I think it is the advocate who can really, or the lawyer who's involved there, who can really help the parties to understand what kind of process of resolution to choose, when to choose, and how to choose. See, I think there are three major things in this: responsibility, as you said, ethics, and duty. Because once a person is engaged to help them out, then it becomes the obligation of that person, whether he's a qualified counsel or not, because anybody else can come also to help this person. So it becomes the obligation of that person to do the best for that person. So first, the lawyer there involved has to understand his or her responsibility, because there is a liability attached to performance and non-performance. So unless, even whether it is in litigation or not, in mediation especially, the advocacy there necessary is with a great tinge of responsibility. So you have to understand that there the ethics involves accountability. How is this going to, is it going to harm the person or is it going to add value? Because the whole point in advocacy is adding value, or even mediation itself is adding value. So I think there is a moral commitment to help the person in distress. And so he or she has to understand that they can help them to choose the resolution process, help them to say that these are the mediators available, you could choose, or even choose a mediator on their behalf, but not go out and influence that mediator. To that extent, they must have a communication, but they must be sure that they stop short of influencing the mediator. I think that's very, very necessary. Thank you.
Thank you, ma'am. So, ma'am, influencing is greater part on the words of ethics of mediation advocacy. That's all.
Exactly.
I request Jawad sir to please.
Yeah, I agree with whatever Uma has pointed out. Basically, let's understand who is the mediation advocate. Okay, a mediation advocate is basically a person who is advising or assisting a party in the process of mediation. So normally what happens is we have litigation advocates to whom I would approach if I have a problem, and I would tell them, and they would, advise me on what would be the best course of action for me to follow. And they would represent me in the court. They will argue the case on my behalf in the court. That is what normally we understand advocacy as being. In other words, they will advocate my cause before the court. Now, when we talk of mediation, the role of a mediation advocate becomes a little more complex when he or she is assisting a party in a mediation. Because here, while you're a litigation advocate, now you're only concerned about your client's cause and how to fit it within the legal framework and get the relief that your client wants from the court. But as a mediation advocate, your responsibility becomes a little more because you are a part of a collaborative process where it becomes important to understand the other person's interests and needs also. So what happens here is that it is not enough if you just understand your client's interests and needs. You also have to make an effort to reach out and understand the other party's interests and needs. And if the other party is being assisted by another advocate, to establish a good rapport with that advocate also, and make sure that that advocate also plays a collaborative role in this process. Now, how do we go about that? Perhaps I think there are, I hope you will be asking those questions at a later point of time on what kind of training and all that would be required to be a mediation advocate. I think I will leave that part of it now. But let's understand that, most of us, when we come through law school, we are trained to be litigation advocates. We are trained to follow a very adversarial process. So we are our whole training focused on how to interpret the law, okay, how to argue before the court, and how to get what our client wants. Now, when we become mediation advocates, it becomes a little, we have to go a little beyond that, because we have to go beyond what our client wants and understand what a client really needs. And in addition to, as I already said, understand the other person's needs. So basically, we have to be, we need to have a collaborative frame of mind. And one of the biggest challenges for advocates who are trained in litigation, who are trained in the adversarial process, is to come out of that frame of mind and get into the frame of mind of where they could be of some use in a collaborative process. So that becomes one of the biggest challenges. And the ethical part of it is, of course, how do you maintain that confidentiality? What happens if the mediation fails? Are you going to use the information that you got through the mediation process to, perhaps, add on to what your client has already got? Are you going to use that information which has been shared in the mediation process? Now, that may become a very issue for a person who is assisting a party as a mediation. Now, that is where I feel that a proper ethical approach to it would be, if I am assisting a party as the party's representative or a lawyer for the party in a mediation, and in case the mediation fails, it would not be fair on my part to take care of the litigation part of it. I think that should be given to somebody else. I think that perhaps is one of the biggest challenges that mediation advocates would face while, playing their role as mediation advocates. So I would just like to stop here and listen to what Viraj has to say about this.
Yeah, thank you. So please, Viraj, ma'am.
Thank you. And thank you to Ms. Uma and Mr. Jawad, because I want to add on to what they're saying, and I agree to it. Just to add on to the ethics, just to go one layer in terms of what Ms. Uma was talking about, influencing the mediator. In mediation advocacy, and what we see, maybe in practice it is happening. I know I see it out here in South Africa, where you do have some people within a law firm who are trained in mediation, and there are others who are the legal representatives, the attorneys, they're not trained in mediation. So when a case comes to that particular firm, what happens is they tend to take that one brief and pass it amongst the partners or pass it amongst the people within the same firm. And what we need to address in that ethically is tampering with that brief in terms of passing it within the firm. The mediator and the litigator or the attorney representing party can't be the same person, for one. You can't mediate and then go and represent a party, or you can't be representing the party and then go, look, I'll now mediate between the two of you. So ethically, there's got to be that distinction between who the mediator is and who the legal representative is. So there's no tampering or no, as Ms. Umar says, influence over the outcome of that process or the control or the actual process itself. So the mediation advocate can be someone who recommends mediation to their party and try not to influence or tamper with who that mediator is. So the chosen mediator shouldn't actually come directly from within the same firm. You don't want to invite conflict of interest. So you have to manage that ethical duty to choose an impartial mediator, someone who is neutral, who has no vested interest in that dispute. So that's my contribution. So successful mediation advocacy would actually to allow the clients to have the best option in that choice of mediator. So putting, three names in a hat from outside influence, away from outside influence, away from internal influence that is inside that particular firm, and allowing the client to have choice in who, both clients, in choice in who that mediator is. So ethically, I think mediation advocates, and we always get flack for this in the industries, how mediators are taking work away from legal representatives. We collaborate with them. And that is what Jawad was talking about, is that collaboration element of mediation must come through from the mediation advocate right from the outset in choosing who the mediator is. So having less influence on that choice of mediator by virtue of suggesting someone that they know could have information just by virtue of sharing the same office space as them. So bringing out those finer principles of mediation, where there's an impartial, neutral, it's a mediator inside a confidential process. It needs to shine right from the outset. Thank you.
Yeah, thank you so much, ma'am, for sharing your viewpoints. I would like to say that majorly influence affects the mediation advocacy ethics, and that too on the successful mediation advocacy too, if we are going to assume that. So now I would like to raise my second question, and my second question is that does the counsel of the parties really affect the mediation process? And what if the parties didn't have the counsel? Sorry, yeah. I request Jawad sir to please answer it first.
Can you just repeat the question, Manya? I'm sorry, I didn't follow it.
Yeah, sure, sir. My second question is, does the counsel of the parties really affect the mediation process? What if the parties didn't have any counsel?
See, essentially, we call mediation as a party-centric process. So that is in sharp contrast to what happens in litigation. Because what happens in litigation is the moment a party walks into a lawyer's office, loses control. Because it's after that, it's completely, a lot of legalese is involved. There are different permutations and combinations of the facts and law that lawyers use to, advance the case of their clients. And there's hardly an opportunity for the parties to express themselves and to speak about what is most important for them. Now, in mediation, that doesn't happen because mediation, as I said earlier, that it's a party-centric process. It's all about those who are in conflict, those who have the problem. They own the problem, therefore they have to find the solution. And all that the mediator does is assist them in the process of discussing, negotiating, and coming to a solution. Now, here what happens is there are two scenarios here. One where they are assisted by lawyers, and the other where they are not assisted by lawyers, where they are directly, involved in the whole process. Now, oftentimes we find that the presence of the lawyers, if they understand the mediation process, and if they are in the true sense mediation advocates, okay, because they know the process, they know how the process, and they know what they need to do to assist the mediator in taking the process forward. It becomes very useful for the mediator to coordinate with the lawyers, to speak to them whenever there is a difficult situation where the parties are perhaps at a stage where they are unable to move forward, or they're not able to know how to move forward. Okay, and what is to be done next? What is the next step to be taken? And this is where the presence of the lawyers becomes very useful for the mediator. So it's always better to be a mediation advocate assisting a party in a mediation. And here again, as I said earlier, that you need a different frame of mind for that. You can't carry your litigation mindset into a mediation, because many times we find that lawyers who come for the parties in mediation start arguing the case like how they would be arguing before the court, and completely focused on the positions that the parties would have taken before the courts. So this especially happens in court-annexed mediation cases that are referred for mediation. Now, this becomes a big challenge, because then we have to have, sometimes we need to have separate sessions with the lawyers to help them to understand how the process works. And this is where the mediator's opening statement becomes a very useful tool. And I always, I insist that the lawyers are there when the mediation starts. Because what happens is, when you're making your opening statement and explaining the process to the parties, a lawyer who perhaps has never been in a mediation, who doesn't understand how the process works, who comes there thinking that it is something like the privatization of the adjudication process, something like arbitration or something, they come there and they adopt a totally adversarial approach. So, the mediator's opening statement becomes a very effective tool to help them to understand what this process is all about, and to move them from that adversarial frame of mind to a more collaborative frame of mind. So the presence of the lawyers is definitely useful, is my humble opinion, subject to what my co-panelists feel about it. And how effectively the lawyers can contribute to the mediation process depends on what kind of training they have had. So that is why we always feel, I think Uma and I'm sure Viraj will also agree with me, that unfortunately our legal training, what we get in the law school, does not teach us about collaborative problem solving. We are trained to be more of problem inflamers. Okay, because we know how to, aggravate the case. Okay, we know how to, exaggerate what the parties have told us from the factual perspective also. It's very important that lawyers get trained as mediation advocates also. The mediation advocacy training would play a very significant role in what kind of positive contribution that lawyers can really make for their clients in the mediation process.
So, thank you. Yeah, sorry.
Thank you.
Thank you, sir. I request Viraj ma'am to please share their views.
Thank you. I agree with the Jawad, because, to have a legal counsel or legal representative in a mediation process who doesn't know anything about the process, they become a barrier to reaching resolution. And they a lot of it is misunderstanding on what the process is, the time taken to unpack the interests and the needs and the concerns and the fears of the parties. They don't see that because they don't understand that, especially if they haven't. And when we talk about training in mediation, we're not talking about just training people to mediate. We're training people to understand the process. A lot of people, I've trained hundreds of people, and they came in there thinking, I'll just know this because I have to tick a box saying I've done this as a module. But once they sit in the training and they sit in a role play and they actually have to see how a mediator functions, even if they leave the training without ever mediating a case before, when a case comes to them and they send it for mediation, they're able to better inform their clients of what to expect. What are the expectations of the process? So legal counsel can be a barrier if they're misinformed or misunderstand what mediation is and how long, especially how long the process it takes. A lot of people think, they have that misconception, if I show up for one session, we're going to be done and dusted in 2 hours. That's not a good mediation. That's a forced outcome, which is probably not what the parties wanted. It was never tested. They have no idea. They're just fearful of this process because they don't know what the outcome is. And a legal counsel needs to understand, as Jawad says, the final decision sits with the parties. So the parties are more involved in the process than the legal representative. The strength of having a legal representative is that they are able to provide advice, which is what a mediator does not do. We provide information, but we don't provide advice. And providing this legal advice happens to the client outside the mediation or in separate sessions with their client, to assess the risks, the advantages, possible solutions. And then the client is then better equipped to negotiate. So the mediator knows the focus is hearing the client's voice, and a legal representative, especially those who just love their own voices, need to understand that they take a back seat. And the mediator in their opening, as Jawadi said, is very strong about that. And also when where they place, especially if it's in-person mediation, where they place that client, they tend to place them closer to the mediator so the mediator hears them first. They don't, what the mediator does, and I'll answer the second part of that question too with this, the mediator manages power imbalances. And the second part of your question is, what if the person doesn't have any counsel? Well, it's not a train smash, because if you were to look at it in terms of litigation, when you go to court, one set of clients will have a better representative than the other. So there's power imbalance in there as well. If you have a strong litigator on the one side and a weak litigator on the other side, there's power imbalance in representing that client. In mediation, where you don't have legal representation or a client doesn't have that, again, that fear comes out that, I'm on a back foot. But here, an experienced, competent mediator will bring back balance into the process using the introduction, using their pre-mediation session where they speak to the clients one-on-one and inform them what the process is, what will be required of them, their opening statement, how to prepare that, how to prepare for the mediation. So the mediator doesn't tend to focus or be biased towards the party that doesn't have legal representation and tend to help them more. The mediator has a balanced approach to bringing both parties and hearing both parties in that process. And that's what that process is about. So whether that legal representative is there or not, it doesn't affect the mediator's, the way the mediator works with each of the clients. It is a balanced, fair process. And that's what the message must come from the mediator to say to clients, whether they're represented or not, that they will each have equal opportunity to engage in the process and be heard. Thank you.
Thank you so much, ma'am. I request Uma, ma'am. Ma'am, I have one more request to you. Like Viraj ma'am said that there is sometimes having a power imbalance between the representative of the parties. So does that power imbalances also affect the mediation?
Yeah, I'll come to that. Thank you, because I had the opportunity of listening to Jawad and Viraj, which has been in detail about this question that you raised. I have always had a doubt about whether parties are adequately supported by their legal counsel, whether they are being informed, because ultimately a mediation agreement is an informed consent. So whether they have that has always been in the back of the mind. So when I was, I think Vinod Deshmukh had written on homeokinetics, and he said once parties come to a dispute or want a resolution, what they are looking at is what is valued by them. And what is valued by them is based on their experience. So what is experience again? Their expectations, what they look at, their concerns and risk factors, what are their goals, and what are the resources or needs that are there, and how is this going to be addressed. So maybe it is concerns, sort of defenses, and who is to better understand this than the lawyer or the person who is engaged to help them. Because once they come there, as I said, the whole thing is value based. Now, when I attribute a particular, as a person in conflict, when I attribute some value to something and the other person doesn't give the same value, then there is a dissonance. So that's where the conflict starts. So it is the lawyer who will be able to tell them that, yes, I understand this is the value that you're assigning, but the other person is also assigning such and such value. Do you think something could be exchanged? Something could be done to tilt this so that you don't say mine is better or your that is of no use at all. So once that tilt happens, that exchange happens, what happens is the offers and opportunities that are explored. So as Viraj was saying, that engagement is very, very important. See, when Jawad spoke about mindful, I mean, the way it had to be looked at, it is more from the mindfulness point of view. There has to be focus by the person who is helping them. And what Viraj said is, yes, you have to listen to their voice. I remember Justice Venkatalaya, who was a former Chief Justice, once when I met him and had a conversation, he said, it's unfortunate today that the lawyers don't understand the pain of the litigants. And I think it's more so in mediation. Because unless the person who is supporting the disputants in the conflict resolution understand the pain of the litigants, they will not be able to understand what is the value they are assigning, what can be exchanged, or what are the opportunities they have. And the next step is optimizing the value. What is the best that they can get out of the situation? And only if they optimize the value, there can be a change. So the whole change cycle itself is understanding the value, understanding how much you're dependent on that value, or you're prepared to understand the value of the others, how much you're prepared to offer or let go of certain things, how you're going to optimize the whole thing. So I think in that way, a lawyer is very, very necessary, because whoever is there is going to help them to focus on, I mean, he or she must help them to focus on what will be the advantage. So this engagement part of it is very, very important. As Jawad was saying, unfortunately, we are not trained. In law schools, what we are taught is different statutes and how to go and fight it out and do the best. And when the client engages you, it is only to do the best and get whatever they want. But mostly it is not what they want that they get. So they have to understand what is their interest or what will be more valuable for them. And I think in that sense, it is going to help them, because that is where they understand that this is something more. Because it is not just what they come to the lawyer with asking, or their demands or their claims. It is the environment also that has to be looked at. What was the situation in which the conflict came? What is the gap between the expectations of both parties? Say, even if it is for a return of some money or some property, when each person makes a claim, taking a particular position, why are they taking that position? So what is the gap between them? What is the image that they have because of which they are sticking on to their position? And how much of commitment the parties are offering? All that can be explored or aided to the mediator only by the lawyers. Of course, the mediator can do it. Today, actually, I was reading an article by Lisa Grenier on transformative mediation. And she says, okay, we can call all names, but then what is the process? Are we having a process that suits the parties? So I think, so that is where the learning comes. As Jawad was saying, they must be trained. They must, we all know that there are some counsels who are not for mediation, who are not for resolution, and who will put in their bit, because of which the parties will not be able to take that next foot forward. Sometimes, as Jawad was saying, when you call them and talk to them separately, they understand. Sometimes they may come out of the advocate's hold also. But I have seen, unfortunately, Jawad also knows that advocate, only after he died, we could settle a couple of cases, because he was always there blocking everything. So that we can't wish that on everyone. But what I'm saying is that sometimes there are difficult lawyers, but what the mediator can do is help them to understand that they could look at an alternative picture. And somewhere along the line, this reality check or whatever you may call it, when that rapport is built between the mediator and the parties and they understand that these are the possibilities. So that is where the empowerment comes. And that is where the power question that you asked also comes. Because until then, as Viraj was saying, you could have very influential, hard-hitting counsels who can get away with anything in court, and the other person may not be able to open their mouth at all. And so that could also happen. But here, what we are doing is, as a mediator, we are trying to slowly persuade them, nudge them towards understanding what is the reality in the situation and what are their opportunities. So I think in that way, because ultimately, what is a mediation? The core of mediation is to educate the parties to understand what has happened there, generate alternatives, and to help them to choose what will be suitable for them. In this process, as I said, there must be responsibility, there must be authenticity, and there must be a fair sense of integrity also. So this value that I'm talking about is not just social values or what are the norms of the society. It is what the person thinks they are entitled to, or what is the person thinking is the value in a particular situation. So sometimes it is the advocate or the legal counsel there who will be able to reflect whether this is right or wrong. And as Jawad was saying, a lot of training has to go into it. I remember both of us had gone to a training of judges, subordinate judges in North India. And one of the young judges on the second or third day, I don't remember, turned around and said, I can't do this. I am a judge. I'm going to listen to both counsels and pass my decision. That's much easier than doing all this reframing and all that. What the heck is this? I can't do this. So it involves a lot of hard work. And that is where I think this power structure, as you said, is not just because of a hierarchy or because of monetary terms or because of social positions. Sometimes the way the person feels also. So that is why learning psychology, learning sociology is also important for a lawyer today. But unfortunately, most of the courses don't have that. And I think that should be incorporated. And more than anything else, if the mediator is aware of the power imbalance because of a strong lawyer on one side or not having a lawyer on the other side, although the mediator will not advise or go to help them in one particular way, but will be able to reframe and sort of put it in a perspective where this party will be able to feel that they can express their mind or they can understand what are the possibilities. So to that extent, as we say, justice must be appear to have been done. The mediator must make sure that because of the rapport that they build, that whatever is done is fair or must appear to be fair. Thank you.
Thank you, ma'am, for such an amazing, insightful viewpoints. I would like to raise my third question. And my third question is, what are the prerequisites required by the advocate to understand conflict while approaching to mediation? I request Viraj ma'am to please answer it first.
Wow, for an advocate to understand conflict, for a mediation advocate to understand conflict, I don't want to go into when we're training a whole module. We have a whole module on conflict and conflict style. So very quickly, when the clients come to the mediation advocate, they've got to understand at what stage of the conflict are they in. Firstly, is it a misunderstanding? Is there tension between the parties? What stage are they in that conflict? So the mediation advocate has to pay attention to what the parties are saying, the emotions that's involved in how they are getting their story across, their version across, and to understand what type of personality does that client have in terms of how they're approaching the conflict. And when we train in mediation, we get people to take a test. So even as you're sitting as the mediator, you yourself have to take and understand your own conflict style. And mediation advocates need to be quite aware of how they handle conflict. So the first step is to understand how they handle conflict. So there's a sort of person that's quite competitive, or they avoid conflict, or they're accommodating to conflict, to accommodating to other people, if they're very compromising, or if they're collaborative. Firstly, understanding that, those are the different styles of approaching conflict. Then they need to understand from their client, how does that client view the conflict? Are they a competitive type of person? Are they someone who, in that negotiation within the mediation, are they going to avoid making offers? Are they going to be very accommodating, take the first offer on the table? What kind of person are they? Collaborative, or are they competitive? So by understanding conflict styles, understanding the stage of where the parties are in terms of that conflict, the mediation advocate has to pay attention to the client. So for me, that's important. That's where this foundation of understanding how your client is going to approach a mediation. I hope I'm aligning to what your question is asking, because that's my understanding of conflict and how we as mediators look at it. And as a mediation advocate, understand that the parties coming to the mediation have varying styles of managing their conflict, have varying styles of approaching the conflict. So if they go into the mediation, and the mediator who's well trained will understand, I'm going to get different personalities in here and I've got to manage it. The mediation advocate has to understand their client's approach to the dispute. What is their conflict style? So the mediation advocate has to know that there's different approaches to it and how to manage that. So when the client goes into the mediation and comes back with information, if the legal representative isn't there, then they need to understand, as a mediation advocate, how is my client absorbing that information, processing that information, and sharing that information with me. So because that's the understanding of how that client is viewing the conflict.
Thank you, ma'am. I request Jawad, sir.
On this aspect of, how to approach conflict, I fully agree with Virash, whatever she has said, because there is, psychological way of approaching conflict. Each person has a different way of approaching conflict, understanding conflict. Now, that part of it, I think she has dealt with very elaborately, so I don't want to repeat that. But what I would like to say is, the framework within which lawyers operate. Okay, now lawyers operate, totally focused on the law. They lose sight of the fact that there are people involved in the conflict. They look at it only from the legal perspective. Now, as the saying goes, law is the handmaiden of justice. But surprisingly, even our Supreme Court has held that where there is a conflict between law and equity, law has to prevail. Now, why this has been declared by the courts is simply because they want consistency. They don't want contradictions. But then what happens is the courts decide or sit on one day and decide a particular dispute in a particular manner. And on the next day, they decide it in a completely different way. Right? So we have seen these contradictory precedents coming out from the courts. Now, what happens with lawyers is they get so obsessed with the law that they forget that law is the purpose of rendering justice. So when we lose sight of the fact that ultimately it is justice that we are aspiring for, we are doing a disservice to the people. Because the people are not concerned with the law. They're more concerned with what is there in it for me? What am I getting out of it? I'm hurt. I'm angry. This is what has happened to me. And what is going to be done about it? Now, this is where a mediation advocate needs to be properly trained to understand this need of the client. Because Uma will watch for it. I don't know how it is in South Africa or in the UK, but in India, we come across lawyers who are so obsessed with the law that they would not agree to a solution that would not fit within their definition of what is legal. So we find this as a big challenge in dealing with the lawyers. Now, this is where I feel that, that the training of lawyers should focus more on solvers, not just as, people who are espousing a particular legal principle. The law exists to help people. So if the law is not going to help people to get justice, then what is the use of that law? Perhaps my views may sound a little bit radical, but I'm just talking about the ground reality, because one of our biggest thinkers, Amartya Sen, has written a book, The Idea of Justice, where he talks about two Sanskrit words, niti and nyaya. So he says that niti is institutionalized justice, which is basically, it's justice according to the law. Now, what he says is it doesn't necessarily translate into real justice that I, as a common person who's aggrieved by something, feels has been done to me. So my feeling is that the whole approach needs to be completely changed. Okay, we need to unlearn a whole lot of things, and we need to relearn. If you look at, conflict, there are two kinds of conflict that, in a very rough way, I'm just dividing that. The conflict between the powerful and the powerless, like, for example, the state versus its citizens. Now, here, the law plays a very significant role, because the law is there to protect the people, and the courts are there to ensure that the law is used to render justice to people. Now, another kind of conflict is conflict between people, individuals, who are more or less placed on an equal footing. Okay, it may arise out of a social relationship, out of a contractual relationship, out of a legal relationship, whatever it might be, but it is between two people. Now, this is where I think that a process like mediation, which is more focused on a problem-solving approach, which is, of course, what is called as facilitative mediation. Now, we have other kinds of mediation also. We have transformative mediation, in which the endeavor is to transform the conflict interaction between the people so that there's a lasting solution. It's not just that one problem gets solved, but that the very relationship undergoes a transformation from one of conflict to one of understanding and recognition and empowerment. I think what basically we need is, apart from what Virash has already said, I think we need a completely different approach to this idea of dealing with conflict, of conflict resolution, of the idea of justice. Thank you, ma'am.
Yeah, thank you so much, sir, for touching us from such a ground reality of this particular conflicts. I request Uma ma'am to please share her views.
I don't know. I think Virash and Jawad have covered most of it, and we have a fair idea about what is conflict. See, when we hear the word conflict itself, when you pronounce it, there is something harsh about it. So, when parties have a difference and they come to the lawyer, immediately the conflict means the lawyer also starts acting only based on the sound that is reverberating in his mind. See, anything in life, we have an image, okay? Whether it's for a simple thing like your family, or you have a difference with your neighbor, we always have an image about everything. And that's where the conflict starts. So for the lawyer also, as Virash was saying, there are different styles of how we approach the conflict, and especially so for the mediator. But when the counsel or the person who's helping the parties is there, his or her frame of mind is also going to affect how the disputants are going to look at the conflict. So what they see or what they hear or what they infer is all based on their own value that I said they put on the particular thing, plus the value that the counsel is also adding to it. So they may have the version from the lawyer, and that would also add to whatever is the layer around the particular situation. So what happens is there is an inability to assess the harm objectively, or to find out what could be done in the process, or to take responsibility for the situation, because the lawyer or the legal counsel there really does not understand what this party wants or needs. Often we have seen in mediation, they may come and say, okay, we came to court asking for all this, but I would be happy with this. So that's why we say interests and needs, wants and needs and all that. But how do they come to that stage? They come to that stage only when there is enough data which has transformed into information. See, there is a lot of data floating around, but what they use as information to think about that particular situation, or what is the dissonance there, depends on how they are supported to look at it. So the way that the legal counsel looks at the conflict also would add a layer, or would help them to peel that layer. Only if that is done in a positive manner, there will be basic understanding and recognition. Without understanding and recognition, they cannot go further at all. So if we are talking about change, we are talking about motivation, we have to talk about taking responsibility for the situation. We have to talk about understanding and recognizing the situation. We have to talk about objectively viewing the situation. And for that, as Jawad was saying, we need proper training when we choose to support somebody in distress in mediation. And the mediator also has to understand that their frame of mind. See, for example, I may not like a husband who chooses to say that, oh, it's okay to physically abuse my wife when I'm doing a matrimonial mediation. That's a simple thing that we can think of. I would be aghast. But if I am showing that, now how is it going to affect the power dynamics that you asked earlier? Or if as counsel I say, oh, he's the husband, so he decided to give away the property to the brother just to make sure that the wife doesn't get it, then where is this mediation going to go? So we have to understand that whoever comes into mediation, and that's why Jawad said initially that I would prefer them to be in the opening statement, because the whole process is very, very important. That's what differentiates it from other settlement processes. So if the lawyer is able to understand, or if the mediator is able to create the rapport with the legal counsel to say, okay, if he's going beyond what is possible or not according to law, then you take them aside and have a separate session, and then you talk to them and find out why they are doing that. And if they are able to come around to understanding, or just say, okay, I'll keep out, you talk to this person, something like that. But then that change has to happen, or will happen only when the legal counsel also understands what is the real need of the parties and wants to help the parties. So as Jawad was saying, I have come into this litigation. Many people have said, you want to refer to mediation? I don't think there's a need. You have a very good case. I remember there was a case in Kerala. For 15 years it had been going on. When I went for a mediation orientation there, and the judge who had reserved orders called me to mediate, I said, I can't, but I would just see what the parties are doing. And when I found it was just a simple word there in the plaint which had created the problem, and they were able to settle. But nobody had put their mind to it for all those 15 years. Evidence had been let in, arguments were over, it was ready for the judge to write the judgment. And luckily, the judge chose to send it for mediation. So what I'm saying is that the lawyers have to be conscious of what is happening in the process. We just can't go through because somebody has engaged me. I can go and shout in the court. That is not there. See, they have to understand what is the purpose in this litigation, or what is the purpose for which the parties have come there. What are their goals? Is it possible to do something? And if there are certain offers, how can we prioritize it? Can we understand? I mean, more important is to understand the potential of the situation. Can we do something creative here? And only when you do that, you can get to a workable solution. And that can also happen only with fusion of needs. See, mostly it is unmet needs which cause this dissonance. Most of it is not even understood or recognized by the parties. And more so when the advocates or the legal counsel don't understand what are the needs of the parties, then the mediator will not be able to help them at all. If the mediator has recognized and then has a conversation with the legal counsel, and they go back and talk to them, because it is the legal counsel that they rely on. It's just like a child running, waiting to see the mother, when the child goes to kindergarten on the first day, the mother waits outside, the child goes inside, but still the child will keep looking back to see whether the mother is there. Gives a sense of security. It's the same thing here. They look to their legal counsel for that sense of security. And that sense of security will come in only when the legal counsel is able to be objective in the mediation process. In the litigation process, it's totally different. They have to fight for their client. But in the mediation process, they must be able to put it in such a way. I don't know how many will understand this, but recently I read I thought it was very good for reframing. In Ramayana, which we have, all of us know that Rama was sent to the forest. And apparently that morning when he came to tell his mother, that he was not going to become the king, he didn't come and tell her, father has decided that I'm not going to be the king. But he came and said, my father has decided that I must look after the forest, so I'm going to be the king of the forest. So what a difference. So she did not rave and rant because he said that. Only later she understood that he was not going to be coronated. So it's the way you put it. The lawyer has to understand that it can be put in a way where they go through another track and find out, oh, this is not bad. I can accept it. So the conflict, as Viraj said, it is very, very important for the mediator, for the legal counsel, and for everyone to be aware of what is their conflict style. We need not preach to them, but they must be able to understand that this may not help. Now, what are you going to do? Because this is a collaborative process. So in the whole process, I think, unless the disputants, the legal counsel, and the mediator are in sync and want to understand what can be done best for the parties will not be able to recognize what is good for them. And I think it is towards that the mediation process must be structured and move. Thank you.
Manya, if I can just share a small experience that I had, it is a bit, you can call it as a bit of a funny experience, because what happened was the mediation started, it was progressing, and the parties were discussing a particular issue, and in walks the lawyer of one of the parties. Now, he was not there from the beginning, he didn't know what transpired when the mediation started. And he walks in, listens for some time, and he interrupts the parties and says, he addresses me and says, my lord, they have not pleaded that. So I told him, I said, see, first of all, I'm not a lord. Let me clarify, I'm not judging any issue here. I'm just, and I said, yes, the pleadings, I don't know what, I have not seen your pleadings, but it's open to the parties to discuss anything they want. But it took him some time to understand that, because he was so obsessed with the fact that he kept on repeating, but this is not there in the pleadings. How can they talk about this issue? I said, it may not be, but please understand that this is important for your client also, because your client also is open to discussing this. Now, this becomes a challenge, because the moment the party heard the lawyer saying it's not in the pleadings, he clamps up. And then he says that, look, I don't want to discuss this issue, because they are raising this for the first time. Now, this is where, mediation advocacy training becomes very important.
So basically, that's where the role of the lawyer and role of the mediator to start with the opening statement, so that parties may get to know that the mediator is not going to be the law, is not going to be judges a statement. Yeah. Thank you, sir, for sharing your wonderful experience with us. Now, I would like to raise my fourth question. My fourth question is kind of a big one. I'm very sorry for that too. But it's like how an advocate can prepare or handle a client for mediation. Like you being all of us, all of you are the expert in the field of mediation. So who do you think is easier to handle, the party or the counsel, to convince the mediator mediation shall be persisted if the first session does not head for the settlement? I request Jawad sir to please share his views.
Okay, that was a very complex question, but from what I understand is, your question mainly is focused on how counsel or the party's advocate should prepare a party for the mediation. Is that right, Manya?
Yeah, yes. And plus added is to that, like if the parties are not going to be ready to listen to that counsel or the mediator, then how come the counsel should handle the parties to go for the further mediation sessions if the first session should not go ahead for the settlement thing?
Okay, see, one of the challenges that lawyers basically face when they're advising their clients is that if they tell the client that, look, let us go for mediation, or let us negotiate with the other party and see whether we can settle this, there's a fear that the clients may perceive it as a weakness in their case and that they may lose faith in the lawyer. So this is a fear that we find to be very common in the minds of the lawyers, because they don't want to appear to be telling the client that, look, you have a bad case, because that's how client may look at it, because that's what I understand. But I think it becomes very important for the lawyer to cross that threshold and tell the client that, look, let's discuss this from what is best for you and what is most important for you. And a set of questions that perhaps the lawyer can ask the client. What is most important for you here? Why is this important? What happens if you don't get it? What are the alternatives if you don't get this? Have the discussion with your client and help your client to understand beyond what the client is feeling or, feeling hurt and all that. What is it that actually the client needs? Is it simply revenge that the client is seeking against the opposite party? Or is it something that has deeply affected the client in such a way that needs some kind of a vindication? Now, whether that vindication is something that the client will really get through the legal process. What is really important for the client? Whether that can be really realized. What are the costs that the client, in terms of time, resources, money, peace of mind, if you have to pursue the legal process? Now, this is the basic groundwork that every lawyer owes to the client. Regardless of whether you're a mediation advocate or whatever you might be. If somebody has come to you, like Khalil Gibran has said, when I became a lawyer 35 years back, my father presented me with a plaque. And it contained a quote of Khalil Gibran. It says, the greatest trust between man and man. Now forgive the use of the male gender here. That is, these are Khalil Gibran's words, so I can't tamper with them. The greatest trust between man and man is the trust of giving counsel. So once a lawyer understands that my responsibility is not to blindly follow my client's instructions, but to see what is best for my client, then the process of inquiry starts. So the lawyer has to ask a set of questions, a series of questions to the client to understand really where this is all coming from. Where is this conflict coming from? How did this dispute start? And how did it get aggravated? How did it lead to the present situation where the client wants to go to the court and seek a remedy? So is it the best course open? It might be the best course for the client. We don't know. But is it really the best course for the client? Or is there an alternative? Would a negotiation with the other side help? If not a direct negotiation, would a facilitated negotiation, which aka mediation, would that help? So how do we approach this? Now for that, it's very important that there should be that element of trust between the lawyer and the client. See, while between a party and a mediator, the trust might be a strategic one, where perhaps the party understands that, okay, this mediator knows what he or she is doing, knows the process well, and therefore is going about this process. That is a strategic trust. But many times, lawyers enjoy an emotional trust with their clients, like how doctors do. because a party may know his lawyer for a very long time. In India, we have a concept of family lawyers. We have people who, not from the perspective of matrimonial disputes. I'm talking about lawyers who are consulted by the father, by the grandfather. For generations, they would have trusted this particular lawyer. And when his son becomes a lawyer, again, they go to the same person. So this element of trust is there. So what is it that how do I use this trust to get for my client what is best for my client? If it is litigation, so be it. I'm not saying that, mediation is a panacea for all evils. I mean, for all the illnesses. It's not, there's no one size fits all. It might be litigation. You might have to go to court. But that is an exercise that every lawyer has to do with the client before taking a call as to what is the best course for the client. So I think that kind of preparation is very important. Whether you're trained in mediation advocacy, whether you're not trained in mediation advocacy, as a lawyer, I think it's a duty that you owe to your client to decide, to help your client to decide what is the best option. How do I go about this? How do I get what I need? To help the client to understand that and to guide the client through the process is very important. And every conscientious lawyer should be doing that. I'll stop there. There are a few more things I would like to add, but I'm sure Uma and Viraj will be filling the gap. Okay.
Thank you, sir. Uma ma'am, what's your views, please? Ma'am, you are mute.
Now you're muted.
Yeah. To add to what Jawad was saying, now, why are the parties coming to a lawyer, first of all? If we see, it's because whatever is the difference with the other person, they are not able to handle, then they feel that they have to go to a third person, right? So it's a stage where there is an inability to handle the situation. Now, how far are they relying on their lawyer for that? Or how far do they trust their lawyer in that situation? If we look at that, we see that, when the parties choose to go to a particular lawyer itself, it is either, as Jawad was saying, because they know this person for ages or for generations, and then they have complete trust in them. But most often when they come, even if they have trust in this person, what they are looking at is to get their wants met. They are not looking at anything else. So what the counsel, even an expert that they approach, maybe it's a construction dispute. And so they are going to a person who is an expert in that. And they want to know what can be done. Today, we have a lot of buildings coming up and there are some disputes. And so people go to an engineer or to somebody else or a financial person who can help them to understand what is the situation. So most often it is family businesses in India. I don't know how it is in other places. Mostly, and especially in South India, you will find all cousins and wives of cousins and everybody else being a partner in the business. So there'll be too many emotions that come in, as Jawad was saying. So the first thing that we have to understand is that there has to be some, when we talk about understanding the perspective of the other person, there has to be some kind of self-restraint. Because all that they are doing when they come first with the problem to the lawyer is, I want this, or this person is an idiot, he doesn't understand that I have a right to it. Mostly it is based on entitlements and expectations. So unless the rein is taken in and they are able to understand that they can't keep shouting from the rooftops about the same thing, but they have to look at it objectively, this is not going to get done. And so that is where the lawyer comes in. And as you expressed this power imbalance earlier, the next thing is also making the parties understand that there must be some kind of self-control, because you're preparing them to come to meet the other person. See, the whole process of mediation itself, as Jawad was saying, you do the introduction, you sort of tone down the whole thing and you help the parties to establish a rapport at that point. What if both of them are sitting side by side with the daggers? Because they are so volatile and there is so much of acrimony between both of them. So it is the lawyer who will be able to help them to understand that they have to listen to the other person. Because The next step in the process is for parties to express whatever is their frame about that situation and why they have come to the table, leave alone going to litigation, come to the table. So they are listening to the other side for the first time in reality, because they may have listened, but it's from their own frame of mind or their own perception of this, or whatever has been superimposed by other people, or whatever, as I said, their entitlements and expectations. So what happens is that it is the counsel or whoever is helping them who will be able to say, look, I can understand, as Jawad was saying, what is it you're looking at? Do you think it's possible to get it? So look at it objectively and then ask them to see what can be achieved with the kind of resources they have before them. So when they take that, what happens is the self-efficacy part of it kicks in. They will be able to understand what is the control they have over the situation, what is it they expect from the situation, and what is it that is possible in the situation. So I think, the whole process, even before coming to the mediation table, is for the counsel or whoever is aiding them to help them to understand that they have to have an objective look about the whole situation, have some inclination to change. What if the other person says this? What would be your attitude? What if this person offers this? What would you do? What if this person is looking at the situation like this? And that is why they took that particular stand. I understand you've been hurt by the statement, but do you think it could mean this? So that is why, that is where you start understand, the parties start understanding the intention behind the whole thing. See, we can talk for ages about motivation and need for change, but unless we understand the intention of parties, as Jawad was saying, yes, I want to kill the other person, so I will see to it that he goes in litigation for long. That's a different attitude. You can't do anything about it. But if the intention is different, if the intention is for the other person just to realize, if the intention is for the other person to apologize. See, sometimes even in people say, okay, all this is possible only in matrimonial relationships or family relationships. But I found even in commercial relationships or workplace relationships, there are a lot of emotions. And somewhere along the way, they may have felt hurt by a word or how they understood the intention of what was said. So I think understanding what is the intention of the parties in this particular process, and then helping them to understand what could be their intention or what could achieve their intention, or rearrange their goals and realign their priorities. And for that, as we said, the person assisting them has to be aware of the conflict style of the parties, has to be self-aware, has to be understanding of whatever is happening in that particular situation. Only then they'll be able to do it. See, we talk about self-determination in mediation. Now, how does a self-determination come? They would have done it even before they came to mediation. Why do we talk about self-determination? They have to make the decision. I'm just going to be sitting there like a rock. Now, why do we say that? Because we feel that unless they commit to something, they are not going to go through with it. And as Jawad was saying in an earlier program, that, if you're talking about enforcement of a mediation agreement, it means you haven't, parties have not come to something where there was a mutual consensus. So it's very, very important that we understand that they are agreeing to it on their own volition and they are agreeing to do a particular act, which means they must have understood the consequences, primarily the cause and what are the possibilities. So the self-determination which we are looking at is not just volition, it is something more. It is acceptance of the situation, acceptance of the possibilities, and to that extent, the person who is assisting them has to support them or to help them move towards, in a way, help them move towards that situation, but also support their decision by pointing out what are the realities in the situation. And I think that's very, very important. And that's where the integrity of the person assisting them comes in, because they are responsible to a certain extent for the satisfaction of the party. Thank you.
Thank you so much, ma'am. Now I request Virash ma'am to please share her views.
Wow, Jawad and Ms. Uma just gave so much of information on your question. I just want to add to what they're saying. When Jawad spoke about people thinking it's a weakness to use mediation, we're not, everybody wants a day in court. Everyone wants to go in and fight and be proved right. That's the ego part of being human. I want to be proven right. Mediation, what happens with the mediation advocate in preparing their client for mediation is to firstly get them to understand it's not therapy. So it's not a weak approach to just sit there and just tell the person, the mediator is your therapist, and they're going to feel sorry for you and you're going to cry, and then they're going to hug you and it's going to be all flowers and incense and everyone's going to feel happy. They have to also prepare them for the tough part of it, and that is, there's going to be difficult questions asked. You're going to have difficult conversations. You're going to have to be honest and open and act in good faith. This is not a tactical approach. So the mediation advocate, their legal counsel, their legal representative has to be honest as to why we're using, and as Jawad has said, is it appropriate? If it is appropriate, why we're using this. So there's got to be that influence and endorsement coming from the legal representative on why we're going the mediation route. And once that talk about using mediation happens, and once it happens with the client, the legal representative must now take a collaborative approach to endorsing mediation. So their speech, the way they communicate to the client, has to be positive towards using that approach. Not as a tactic, not as a strategy, not as an abusive process to extract information, which we can use, because that's what Jawad and Uma's also spoke about, is why are we here? What are we using this process for? The negativity must be taken out of using mediation, because yes, you are going to be in a confidential environment where the person is going to express a lot more than they would on paper in litigation. So what are we going to do with that information? When we come back, when we regroup to discuss this information, what are we going to do with it? And that's where they have to maintain that collaborative approach. So using that process of mediation also invokes within the legal representative that we are now in a collaborative problem-solving process. We need to act accordingly. And then the second part to that is to prepare the client that the mediator is going to play devil's advocate now and again. They are going to ask you difficult questions. That doesn't mean the mediator is a bad person. So the legal representative must not take the opportunity to badmouth the mediator, because somewhere in the legal profession, there is that bad mouthing of mediators. And once you begin to be part of this process, don't badmouth the mediator, because the mediator has to ask the difficult questions to elicit information, to do part of that reality testing. They will ask, and so a mediation advocate or the legal representative needs to be fully informed as the roles, duties, and functions of the mediator. So they don't get their client to turn against the mediator. Sometimes we see mediation where one client is so convinced by their legal representative that they have such a great chance of winning something. When the mediator asks difficult questions, then the client then bad mouth and says, the mediator didn't give me what I wanted. But that's not what the mediator is there for. Like Uma spoke about, that decision-making, that autonomy rests with the client. And that's what the legal representative needs to get across to the client, that you are the final decision maker along with the other parties. So the mediators, we take that stance that we are neutral, we're impartial, we're not here to make the decision. And that information, that education needs to come from the legal representative in preparing their client for mediation. Now, when you ask that question, that part of the question where you said, well, what happens if there's no settlement in that first session? Who becomes easier to deal with, the party or the counsel? Well, there isn't usually settlement in the first session if it was a short session, because the mediator has to unpack the reasons why they're there. They are now in an interest-based negotiation phase where you have to unpack exactly what is the most appropriate outcome for them, that's fair to them. So I know there is that fairness element to it. It's not fair of what the mediator thinks is fair. It's not fair what the legal representative is fair. It's what the parties think is the fair outcome. So the legal representative there has to say to them, look, there is no time limit. In South Africa, we have, in our rules, 30 days to mediate, but it's a guideline. It's not saying within 30 days, it's got to be an outcome. So if in the first session you don't reach settlement, at least the process has started. At least you've shared information. You know where you are. You know where the other party is. You started to become comfortable and you feel the process is safe. That's okay. That's what the mediation environment does. It opens up communication. It opens up collaboration. So in understanding that, the counsel needs to understand that they have to communicate to their client. It may not happen in the first session. You need to be okay with that. So the counsel needs to be okay with it. And by, as Jawad was saying in his story, the client clams up if the legal representative says something and which is against what the mediator says, the client shifts towards a legal representative, because in the end they feel, I'm paying this person for their expertise and their guidance. If they say I shouldn't go back to mediation, I'm not going back. So the legal counsel needs to be aware that mediation is a process that takes time and needs to then educate their client as such. So the client becomes easier to handle if the counsel is fully informed and well informed on what the process is. Thank you.
Thank you. Yeah, thank you so much, Viraj ma'am. It's very amazing to listen to all three of you on these amazing, interesting questions. Now, as we are very time constrained, so I would like to jump to my last question. My last question is, what type of training is required to understand about the mediation advocacy, and is it using mediation advocacy can be fearless in terms of losing client or fees inconsistent to take the path of litigation? I request Viraj ma'am to please answer it first.
I'm going to ask you to repeat the second part of the question, because I heard the first part, what training the students or the mediation advocate needs to take. I wasn't quite sure what your second part of the question was. Could you please repeat it?
Yeah, I would like to repeat my whole question itself once again. My question is, what type of training is required to understand about the mediation advocacy, and is it using mediation advocacy can be a fearless in terms of losing client or fees in contrast to take the path of litigation?
Ooh. So firstly, I'm going to say from a South African perspective, it's mandatory to consider mediation prior to litigation if it's a high court matter. So their lawyers will lose fees if the court finds that they obstructed the clients from using mediation. And we do have case law on that. So there, I'm going backwards, back to front. Losing fees in what sense? Because you always put the client's interest first. What is the client's interest in this matter? Is the mediation appropriate? Like we've discussed earlier, then you go the mediation route. Because if you, as a reputation, your reputation is, I look out for my client's best interests, your practice will never be empty of clients. People will want to come and use a competent lawyer. And a competent lawyer will look out for the client's best interests, and by choosing the appropriate dispute resolution forum. If you want to be seen as a hard hitter litigator who fights in court, and the client finds out, listen, there was a better approach of going to mediation because I was actually in a dispute where it wasn't so conflict driven, as it was just a dispute with a few issues that could have been resolved outside a courtroom. You want to retain that client and say, I'm giving you the best service by offering you mediation. And that client will then recommend you as a lawyer to be used as a lawyer who sees for the client's pocket and time. And so that will improve your reputation, your brand as a lawyer, and bring clients to your doorstep. Now, in terms of mediation advocacy training, it's available everywhere, as I've seen online. And it is necessary to understand how to use the process, how to be involved in the process, how to prepare for the process. So I don't want to take up too much of time from Jawad and Uma contributing to this. So if there's mediation advocacy training available, please do attend it, because you will be giving your clients a better way of understanding the process and preparing for the process, which makes you look like a more competent legal representative. Thank you.
Yeah, thank you, ma'am. I request Uma ma'am to please share her views.
I agree with Viraj. I think she has spoken elaborately on the whole issue. Jawad and I have been talking about this mediation advocacy, I think, for more than 10 years. And he's also started doing programs. And I think, as she said, there are a lot of programs being offered online, and people have to do it. See, today we have gone even, restorative justice at one point of time was something new. Today, we've gone beyond that to therapeutic jurisprudence and all that. So there is a lot of psychology involved in every aspect of the matter. So I think, learning advocacy is very, very important, or as part of the training to be a counsel, especially when you do law. I think it's very, very important, not just for this, but even in court, how to address your judge or how to handle the other side lawyer also. You need certain skills, and that would help. So I think as far as that part of the question goes, there's no doubt about saying that everyone should be trained in mediation advocacy. It's very, very important. And once we get trained, we understand what are the skills we need. I can't go into it elaborately here, but I would like to say that it is a different approach to the whole scenario of a resolution. So whoever is involved in mediation or assisting parties in mediation has to definitely have a training. So that's very, very important. Then the other part, what was the question you asked? I forgot that. What was the other part of the question? It was about legal fees. Yeah. So see, I always say this. Initially, when we started doing mediation, a lot of them have said, no, we are, and there has been opposition in various courts for mediation to come in also. And everybody felt that it would take away their practice. And my answer always has been, how did you become a lawyer, or how did you establish your practice? It's just by reputation of a person who's doing good work. And as Viraj was saying, once the clients understand that you are doing your best for them, they will be able to explore the option of mediation when you suggest it to them, if it is appropriate. Okay, so there you may have a fixed fee for litigation, and it may finish even before the whole thing started. But the parties, once they have benefited for the whole process, it's not that they're going to deny. Of course, there are instances where people don't pay you, but I think that also will change over time. Because the whole fee structure is something which is totally a different aspect of your legal practice. But what I want to say is that that cannot be the only reason for not thinking about mediation. Thinking that if I suggest a mediation, I'm going to lose out on my fee that I would get as a litigator. I don't think it's the right reason, because whether you help the parties to litigate or to mediate, ultimately what they want is their goal to be achieved, or some expectation to be met, or to find satisfaction in whatever they are getting ultimately. So if they are able to save on their time and money and still able to achieve some level of satisfaction, or they have consented to a workable solution, I think they are not going to deny the counsel the fee. So I don't think that financial aspect of it should come in the way of suggesting mediation to the parties. But it is necessary that when you suggest mediation, you should be ready to offer the skills that will be necessary for the parties to participate in mediation. If you just say, okay, you can go for mediation, that's only between parties and the mediator, I'm not going to come there, then that is washing of your responsibility. A lot of lawyers do that. They say, okay, it's between the mediator and the parties, I'm not going to come. And they will not, as Viraj was saying, at every stage, they will go back to the lawyer or the person who is supporting them to ask for, help or to discuss the issue. But if you say, okay, if it's a matter in mediation, it doesn't matter to me. Or they will come and say, see, mediator, this is what has been happening to my client. So why don't you advise the other side to do this? So we have to tell them, no, I'm not here to advise. So the parties must also come in knowing that the mediator is not going to advise them or advise the other party to do something else. So to that extent, when the person who has been engaged for litigation or has come to them for advice helps, offers mediation as a appropriate process, they must have the necessary skills to sort of put them in the groove for them to carry on after some time. See, once they get into the groove, once a rapport is established with the mediator, they will be able to think. But until then, it is a person who is nudging them towards the process, who is telling them. It's like you take a child to a swimming pool. You just can't throw the child into the water. You must say, okay, touch the water, feel its temperature, and then go ahead. Or you can just wave your hands, wave your legs, something like that. Then they take to the water. It's something like that. So it is this person who is going to lead them into that situation. So to that extent, they must have the skills. And I think that is more important. And for that, as we have all been saying, training is very, very essential. Thank you.
Thank you, ma'am. I request Jawad sir to please share his views.
Okay, this question is one of my favorite topics. So, but I'll try to keep myself very short because I understand that we are running out of time. See, Viraj spoke about the South African context. I wish it was here in India too. Unfortunately, we don't have it still. Lawyers are not penalized for not advising parties to go for mediation, which I think they should be. But nevertheless, now the situation here is this. First, like on mediation advocacy training. Now, there was, we had this former Chief Justice of India, Justice Bobde, who the curriculum of the law schools should include mediation training also. Now, because it came from the Chief Justice of India, the Bar Council of India hurriedly passed a resolution, issued a circular. But what happened was the moment Justice Bobde retired, the circular also retired. There was no follow-up. So we were very excited with this whole idea. Bar Council wrote to us, and people like Uma, me, we started, preparing the curriculum, and we worked on it with several of our colleagues. All that work went down the drain simply because the Bar Council of India lost interest, because the Chief Justice who recommended that retired, and they're not bothered anymore about what a former Chief Justice has said. It has to be from the current Chief Justice of India, only then they will adopt. Now, unfortunately, that is the politics of our country. There's nothing we can do about it. I'm sorry I'm talking about this here, but I think I have to say this because this is something that really upsets me a lot, and I needed to express myself on that. But, mediation advocacy programs are there. We are also offering that, but I don't want to use your forum to advertise my mediation advocacy training programs. But there are programs that are being offered by different institutions in mediation advocacy. And one of my friends said mediation is an idea whose time has come. Okay, in India. We have been late in embracing it, very late, in fact. We are way behind countries like UK and South Africa and Singapore and so many other jurisdictions. We are way behind them, but it's an idea whose time has come. People are losing faith in the legal process. And unless we give them an alternative, there is going to be utter chaos. Okay? And people are not going to respect. Already they have lost that respect. They are going to extrajudicial fora like police stations or, engaging henchmen to settle their disputes. A time will come when we will perhaps go back to those dueling days. So if I have a dispute with Virash, I challenge her to a duel and we try to shoot each other dead. So something like that may happen ultimately. We will go back again to the medieval era. So unless we do something radical, something drastic is required today. So there is definitely a need for mediation advocacy training, and there is a need to incorporate this in the curriculum of the law school. Turn out not mercenaries, but lawyers who have empathy, lawyers who have concern for their clients, lawyers who are focused on solving the problems of their clients. Okay. Now, insofar as the loss of fee is concerned, as I said earlier, I wish we had the South African situation here. But what happened was we were deputed to a small town called Sirivalli once to talk about mediation to the lawyers there, to the bar. And we had this huge hall there where about 300 to 400 lawyers had assembled to listen to us. And while we were talking about mediation, one elderly lawyer stood up and said that this is a conspiracy against the legal profession. And you guys are here to destroy our livelihood. And there was pin drop silence everywhere, and everybody was looking at us to see how we are going to respond. But fortunately, what happened was a very young lady advocate stood up. And she said, she told her story. She said that my sister-in-law was pregnant and we took her to the hospital. There was nothing wrong with my sister-in-law. It could have been a normal delivery and she would have recovered in a day. But the doctor said, we need to do a cross-section, a cesarean surgery, operation. the coming of a new member of the family is always a very happy occasion for everyone. And normally we thank the doctor by, presenting with sweets and, gifts and all that. But because we spent 6 times the amount that we would have spent for a normal cesarean, we felt very sad because my sister-in-law had to go through all, recovery from the surgery and all that. So it's the same way with our clients also. Don't you think our clients feel the same way? Because they come to us trusting us, believing in us, and they want us to show them the right way. And if you are not going to do that, how do you think they will think about us? And that was it. That changed the whole scenario there, and people were all wrapped with attention, and they wanted to get trained as mediators, and the whole atmosphere changed over there. So what I'm saying is it's ultimately a conscience. You're answerable to a conscience, regardless of whether the law imposes a penalty on you or not for advising your client correctly. Ultimately, it's your conscience. As I said, I quoted Khalil Gibran. You're enjoying the trust of the people. How well you're going to live up to the trust is in your hands. You decide. What would you like to do? Okay, even if you're going to be losing out on the fees, if it's going to help your client, please advise me. If it's not going to help your client, advise litigation. But if it is going to help your client, but because you want to earn more money, you take your client into litigation, you have your own conscience to answer for. And who am I to tell you what to do? I'll stop there. Thank you, ma'am. Sorry if I became a little emotional.
No, sir, it's always amazing to hear such amazing experiences. Yeah, I'm very thankful to all the panelists, to all the audience for hearing us from such a long period and for having us great time. And I request everyone to please fill the feedback form also if it's opening now. I think it's opening now only. Yeah, and if anyone have any questions, because we are very time constrained and it's already over because it's past 6:37 now in India. So if possible, we would like to have your questions in the end after the, actually, sorry, it's the end only. Yeah, we can have your questions at our email IDs. You may share it with us, and with the help of this panelist, we can share it on our LinkedIn profile and you may have it from there. And I am very I apologize for the same thing. Here is our email ID. I've shared in the chat box, please. You may have a look on that. And I'm thankful to all of you on behalf of the Karuna and on behalf of our founder, Mr. Sahil Kapoor also. And I request at the end to all our panelists to please share their views for Karuna mediation. I request Uma ma'am to please share their views.
I want to congratulate you actually, because although we have been talking about mediation advocacy for a long time, it has come to be recognized as a very important facet of practice. And today, with different viewpoints, I listened to the earlier where Push Gupta and others were talking, and I was also thinking that we need to have more discussions and bring in more perspectives. And it was nice to have these questions. Of course, whatever time you have is never enough to discuss such topics. And so this 1.5 hours was really not enough. And I'm especially thankful that I had a chance to share my views with Viraj and Jawad, because the kind of commitment and passion that they've brought in here shows that although mediation has a long way to go, it's in the right hands. So thank you. And I think especially for Karuna mediation, to take this initiative and bring in more discussions like this is going to help a lot of people. Thank you.
Thank you so much, ma'am. I request Viraj ma'am to please have a view on us.
Thank you, Manya, and thank you for the invitation to be a part of this panel. I didn't know at that time that Ms. Uma and Jawad were going to be a part of it. And then when I saw the marketing post, I was like, oh my goodness, I'm with the greats. So thank you so much for making me a part of this and including me. I really appreciate it. And I do hope it was insightful for everyone. I think we have so much more to contribute. And I wish Karuna Mediation all the best and all the success in the work that they do. Thank you so much.
Thank you so much, ma'am, for being such for a longer period of time, and thank you for accepting our invitation too. And I request Jawad sir to please share his views.
Thank you, Viraj, for making me feel great. I would really love to believe that. But anyway, I mean, it was an awesome session with listening to Uma and Viraj. And Manya, your questions were very incisive, and I mean, they really challenged us to come up with our deepest thoughts and what we really feel about it. And thanks for providing us with this platform. It's excellent work that you're doing. My congratulations to you, to Karuna Mediation, to Sahil for starting this starting this initiative. So my best wishes to you, and we are always there to cooperate and work with you at any time that you need us. Very grateful to the audience for their patient participation and for listening to us so patiently for such a long time. Thank you so much.
Yeah, thank you so much, sir. I request Susan ma'am also to please share her views.
Sorry, my views. And there's so much wisdom in this session, and fundamentally, we have so much in common. And I just wanted to share one thing in response to law dispensing justice. A lot of people in the UK describe the law as an ass being a donkey, which was always perhaps unfairly dubbed as being a stupid animal. And, what you said, all of you said, but in particular what Jawad was saying about sometimes lawyers lose sight of justice for the parties really struck home with me. And I know that it's something that a lot of lay people, non-lawyers in this country really empathize with that feeling, because they don't feel that the law always serves up justice in the appropriate way. But I really enjoyed the session. Thank you very much for inviting me.
Thank you so much. Thank you, everyone. It's such a wonderful having great time with you all. And I thanks to all the panelists for such a great time from their timing schedule. I know they all are very much busy in particular timings. And thank you, everyone. I request you may now leave. If you have any questions, you may please follow us on our LinkedIn ID, or please share us on our email also. We can have it particularly very soon on that. Thank you. Thank you, everyone.
I would like to thank Reverend David Barker for joining us today. Thank you, sir.
Hello, sir. Thank you so much for joining us. Thank you, ma'am. Namaste to all.
It's been great. Thank you.
Thank you, ma'am.
Thank you, everyone. It was very good. I really enjoyed it. And AJ, it was good to see you again.
Yeah, thank you so much, sir. Thank you, Viraj, ma'am.